Justice is expensive in the Bryan Kohberger matter. Lori Vallow's attorneys argue for her request for a new trial. How did that turn out? Conor McGregor, well, he could be in some big trouble. Daniel Penny, he was indicted. Is there a deal in the nightclub massacre case to avoid a trial? The Moscow Mule killer mom not helping herself by her emails. Another story for you can't make this up file. And has Richard Allen confessed to being the Delphi murderer? And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell for notifications. And remember, you can listen to us anytime on any of your favorite podcasting apps. So let's go ahead and get to the docket for June 16th, 2023. Now, we didn't do a docket yesterday because, frankly, well, court got in the way. And it was a huge mess getting to court because of the NBA championship celebration parade yesterday. I didn't go to it. No, I was in court until 4:15 yesterday afternoon. So my apologies for not getting a show out to you. So let's go ahead and get to it. No, and one more thing. Yesterday was also the lovely Miss Kristen's birthday. So a big shout out to her. Happy birthday. All right, first on the docket, Bryan Kohberger. Things are getting expensive. That's right. Prosecutors are obviously beginning to prepare for the trial of Bryan Kohberger. And guess what? It's all about the money. The prosecutors are asking for a little bit of an increase in funding to cover trial expenses. And the Latah County prosecutor, Bill Thompson, has submitted his annual budget request to the county commissioners. And he's asking for roughly $135,000 for trial expenses. Usually that budget amount is $15,000. Now, the trial is set to begin on October 2nd and is expected, obviously, to be lengthy and considered to be complex. And the prosecutors anticipate, well, they haven't decided, but they could seek the death penalty, which makes things even more expensive. Now, the prosecutor said it's hard to project exactly what's going to be involved. We know that it's not going to be cheap. It never is. And Mr. Thompson's budget request lists potential expenses to include compensating expert witnesses, travel fees, transcript fees, and exhibit displays, basically paying for somebody to create nice trial exhibits. Justice is expensive, ladies and gentlemen, and they always find money for justice. Next, as it relates to Bryan Kohberger, the prosecution has no objection to a reasonable extension for the defense to comply with its obligation under the criminal code, basically stating that, hey, we would expect the same reasonable time period to respond if the defense actually provides a notice of alibi, and then we would want to be able to comply with that as well. Not uncommon. That's just the way things go. The Idaho code basically states you have to let somebody know within a certain limited time period after arraignment. A lot of states, it's 35 days before trial. Not uncommon to seek a continuance of that. But you would think, now I'm just throwing this out here for thought, if you had a rock-solid alibi, would you need more time for that? Wouldn't you just say, hey, attorneys for Bryan Kohberger, here's my rock-solid alibi. Go present this to the district attorney who can look at it, evaluate it, and clearly determine it wasn't me because I have a rock-solid alibi. Or maybe that request for continuance is that there is no alibi, but it's just a request to give them options down the road. Now, the attorneys for Bryan Kohberger have also filed several documents challenging the indictment. And the lawyers claim that they are certain exculpatory evidence. That's right. Exculpatory evidence is evidence that reduces one's culpability as it relates to a crime. And they believe that this evidence needs to be turned over so that they can clear their client's good name. Now, Mr. Kohberger, as you know, was indicted for the 4 counts of first-degree murder and a single count of burglary back on May 16th by the grand jury. Now, Kohberger's lawyers are demanding the state to turn over items of evidence that the defense claims could prove his innocence of the quadruple murder. The state and the defense have since been battling over what grand jury materials to provide to the Kohberger team. We talked about this somewhat the other day, and the defense is now arguing that after 6 months of extreme media coverage in such a small community, revolving around such a high-profile case, that they have the right to determine the grand jury selection process to make sure it was done fairly, and disclosure of any exculpatory evidence presented to the grand jury. Exculpatory evidence doesn't have to be presented to the grand jury. They know that. This is boilerplate standard requests, but the prosecution has to respond and the defense has to ask. And the defense is also arguing that since the death penalty is a possibility here, and he has not waived his right to speedy trial, that the state's failure to provide all the requested materials obstructs their ability to make a defense for their client. And the defense attorneys also state that all such evidence, if not turned over without delay, that the court should temporarily halt the proceedings to allow for sufficient time to conduct an appropriate review of the grand jury proceedings. Well, I'm not sure how you halt the proceedings or stay the proceedings, and well, that would require tolling of speedy trial. But Mr. Kohberger apparently doesn't want that. So I'm not sure how the court is supposed to comply with that over Mr. Kohberger's objection. We'll keep bringing you the news, ladies and gentlemen. We'll bring you the arguments for the prosecution and defense, and we'll tell you if it's legitimate or if it's, well, ridiculous. Next on the docket, let's talk about Lori Vallow. She had a motions hearing yesterday regarding her request for a new trial. How did that work out for her? Well, not so well. Obviously, the defense tried to argue the jury that convicted Lori Vallow of murdering her 2 children were influenced by outside sources. Lori Vallow obviously was found guilty of killing her children, J.J. Vallow and Tylee Ryan, back in September of 2019, after believing that they had somehow become zombies when she fell in love with Chad Daybell. Now, she was also convicted in regards to conspiring to kill Tammy Daybell as well. And anyway, the prosecutors argued that she became obsessed with the idea of this impending apocalypse, and the only way to save their children's souls so they could be among the 144,000 survivors was obviously to kill them. Makes complete sense, does it not? No, it doesn't. It's ridiculous. Most end-of-world stuff, kind of ridiculous, okay? I'm sure there will be an end of world someday, but I don't think anyone's going to be able to predict it. Just throwing that out there for you. Anyway, Lori Vallow's attorneys argued that the instructions given to the jury were confusing and that at least one of the jurors knew information about alleged crimes that were not entered into evidence. Remember, that was given in an interview with the press there in Idaho. Anyway, the retrial request was fueled by this interview that was given to the East Idaho News shortly after the trial was over. And in that interview, juror Saul Hernandez noted details about the deaths of Vallow's husband, Charles, that were not even mentioned in court. Well, Vallow's attorneys alleged that the changes in the original indictment should justify a new trial as well, which they argued was without proper notice from the prosecution. The prosecution countered that any changes to the indictment can be made at any time before the prosecution rests. Yeah, that's the law there, but you would think after 2 years you would probably notice that, unless maybe you were trying to play games. I don't know. I'm curious to see if the prosecution is going to amend the indictment statute in which they're proceeding on under Chad Daybell, if they intend to do that, or if they're going to wait until their last witness to do so in his trial, which begins April 1st in 2024. Anyway, Judge Boyce obviously presided over the trial for Lori Vallow and rejected the motions at the time in trial and rejected all of the defense arguments as it relates to a motion for a new trial. The judge said, yeah, no. Now, we've mentioned this before, but it's an oldie but a goodie. But what's the difference between a district court judge and God? That's right. God doesn't think he's a district court judge. District court judges do not admit that they made mistakes. That's what appellate courts are for. So if anyone thought, and I certainly didn't, think that Lori Vallow is going to get any relief whatsoever on this motion for a new trial. Rarely ever happens, and Judge Boyce is certainly not going to be so bold as to do that. Now, one of the things that the defense made a mistake in is that they never actually introduced the interview from the East Idaho News into the record. So it's not part of the record for the court to consider. And that's one of the reasons why the court noted that, well, there's nothing in the record other than you simply stating that this interview took place. A lot of people think, and sometimes attorneys apparently do, is that if they state it, it must be true. No, you have to have a hearing, call witnesses, introduce evidence for that hearing. Otherwise, it's not really part of the record. And you know what they call that when you don't do that correctly or properly? Potentially ineffective assistance of counsel. Throwing that out there. Anyway, the court's order was rather simple. The defendant's motion for a new trial is denied for the reasons stated on the record during the hearing. Boom. We're going back for sentencing end of July. Next on the docket, Conor McGregor. He could be in some big trouble. Now, I kind of liked Conor McGregor. I actually saw him at the exhibition fight where he made like his $100 million for fighting Mr. Mayweather. And Mr. McGregor lost, but he still got $100 million. He's kind of a flamboyant guy. He's had some run-ins with the law, but this one could be big trouble. Who knows what took place in the restroom. So a video has emerged of the moment that Mr. Conor McGregor led his alleged sexual assault accuser into the bathroom at the NBA Finals in Miami last week. And the video shows his entourage of security guarding the door while Mr. McGregor is inside with this woman. Now, the MMA fighter, who's expecting his fourth child with his fiancée, has been accused of forcing the unnamed accuser to perform oral sex on him and attempting to sodomize her in the VIP men's bathroom at Game 4 of the NBA Finals last week. In a statement on Friday, the spokesperson for the Miami Police Department stated that the Special Victims Unit is investigating a report that was filed on Sunday, June 11th, 2023. This is an open investigation, so they are not going to make any further comments. Now, a source related to Mr. McGregor apparently said that he will cooperate fully with the investigation. He insists that this woman's claims are false and that she is only interested in money, which we'll talk about in just a second. As you can see, the footage shows Mr. McGregor emerging from the bathroom, then approaching the woman, taking her by the hand, and then walking back towards the bathroom with her. She follows him, and then they disappear behind the door. Mr. McGregor's entourage of security guards is then shown blocking the entrance to the door. McGregor's attorneys say that footage undermines the woman's original allegation that he and his security guards forced her into the restroom. The woman's lawyer now has changed her story. Mr. McGregor welcomes the investigation, which he firmly believes will show the claims against him are false. Now, after not responding to the demand for money made by the woman's counsel, she turned to the media to apply pressure. McGregor's camp says this is nothing more than a financial shakedown. The accuser's attorneys originally said he had forced her into the bathroom with the help of his security. After the release of the video, she issued an updated statement saying that the woman thought she was being led out the venue to go to the Four Seasons where he was staying. The statement says, my client was under the belief that they were leaving and going to the Four Seasons Hotel, as Conor had previously asked her to join him at his hotel room. She maintains that someone approached her and said, Conor told me to get you. As she was walking out of the venue, she says McGregor took her by the hand into the restroom, and my client believed that they were leaving, but Conor took her into the restroom instead, according to her attorney. Originally, she said in her letter that Mr. McGregor aided and abetted by the NBA Miami Heat, and the arena had the victim physically forced via security into the men's bathroom, separating her from her friends and trapping her inside with Mr. McGregor and his security guard. This was all in the letter that they sent to say, pay us money. It went on to claim that she was trapped and then forced himself upon her. Mr. McGregor then appeared from inside the handicapped stall and shoved his tongue in the victim's mouth and then aggressively kissed her, according to the letter. The woman's attorney says that she then told him that she needed to use the restroom. while she was in the stall. The woman says that Mr. McGregor then pulled out his private parts and shoved it down her throat. She claims that she could get Mr. McGregor off of her. She then tried to flee, but says McGregor then aggressively grabbed her, pinned her up against the wall, and then tried to sexually assault her. Now, Mr. McGregor's apparently was not in a state of arousal, and then the victim continuously elbowed Mr. McGregor and finally escaped, according to the alleged victim's attorney's letter. Now, both the Miami Heat and the UFC issued statements in the incident. The Heat said we're aware of the allegation and they're conducting their own investigation, and pending the outcome of the investigation, they will withhold comment. Now, Mr. McGregor has been previously accused of sexual assault by 2 women in Dublin, Ireland. The first claim was a woman back in December of 2018. After she came forward, a second woman reported that he attacked her in a car outside of a pub. He was questioned by police, but released without a charge in 2021. And Irish prosecutors announced that they were not pressing charges in either case. The first accuser sued Mr. McGregor civilly, and the case is ongoing. He's also been arrested in the past for assault and battery charges. Now, who knows what actually took place in that restroom stall? Certainly not the most romantic place in the world, for sure, but it seemed like perhaps if she thought she was going to Mr. McGregor's hotel room at the Four Seasons, I don't know if she thought she was going back for dinner, to look at the view. I don't know. But consent can change rather quickly to non-consensual, like I said, in the drop of a hat. Or in this case, maybe a drop of the trousers. Don't know what happened. We'll give Mr. McGregor the benefit of the doubt. But I think it is a little odd that a written demand for money was made. Normally people go to the police and save the money demand for much later. Something to think about, ladies and gentlemen. All right, next on the docket, Daniel Penny. Remember the Marine that was charged with the death of the homeless guy that was threatening people on the bus, on the subway? Well, a grand jury has indicted Mr. Penny for the chokehold of killing Mr. Jordan Neely during that subway confrontation last month. And obviously, Mr. Penny and his attorneys have vowed to aggressively defend their client in court. The attorney said that the decision by the grand jury sitting in Manhattan arrives weeks after Mr. Neely was caught on camera, and the death sparked a national firestorm over Penny's actions and intense scrutiny over the floundering mental health system that failed to help the victim. Now, Mr. Penny, 24, faces one charge of second-degree manslaughter and another charge of criminally negligent homicide. The criminally negligent homicide could put him in the state prison for up to 15 years. The other charge is a sentence of up to possibly 4 years. Mr. Penny's attorney said they are fully committed to clearing his name. While we respect the decision of the grand jury to move this case forward to trial, it should be noted that the standard of proof in a grand jury is very low, and there has not been any finding of wrongdoing. All correct statements. Standard for a grand jury is probable cause. Would a reasonable person believe that a crime was committed and the defendant may have had something to do with it? Very low standard. The former Marine, infantry guy, squad leader, is free on $100,000 bail at this time. He first surrendered to the police back on May 12th, nearly 2 weeks after the Neely situation, and he was actually charged. Now, Mr. Neely, the dead guy, had a very long history of mental health illness and scores of run-ins with the New York's police department. And this particular day, he was yelling at strangers, threatening them, and throwing trash around. In a series of videos released, Penny said that he felt an obligation to step in, and if Neely had carried out his threats, he would have killed somebody. That's what Mr. Penny believes, and that's going to go to his state of mind as to his state of, when he testifies at trial, that he was defending himself and others. Penny seized Neely from behind with a common grappling technique called a rear naked choke and dropped to the ground as he and 2 other men tried to restrain the struggling Neely. Now, a freelance journalist who happened to be on the subway recorded the incident, and obviously it sparked a little bit of outrage in some parts of the community. Penny said he wasn't trying to kill Neely when he grabbed him, but he couldn't sit around while Neely ranted. There's a common misconception. Penny stated that Marines don't get scared. We're actually taught one of our core values is courage. And courage is not in the absence of fear, but how you handle it. He said that he was scared for himself, and he looked around and there were women and children and yelling in their faces with all the threats, and he said he couldn't just sit still. The medical examiner later ruled in Neely's death a homicide, and a troubled former street performer died from compression of the neck. And of course, Neely's family, of course, not near him during this time, blamed the authorities for not making sure he got the care he needed. Do you get that? It's the state's, it's the city's fault that he didn't get the care he was needed. This is always what gets me, ladies and gentlemen. I get it. People don't deserve to die. There's victims out there. But when people are out there and they got issues, the family suddenly blames everybody else. And then they all are going to show up for court with all their little T-shirts on with the victim's face on it. Where were you when the guy was threatening people on the subway? Where were you? Where were you when the kid was out gangbanging in the wee hours of the morning and gets shot? And then you say it's the police department's fault? It's the city's fault that they didn't get the resources that they needed? Are you kidding me? That's right. The government has limited resources, and they have to use them on people that actually want to take advantage of those resources. Mr. Neely has had many opportunities and chose not to take advantage of them. Let me know what you think. Am I completely wrong on this? Or I get it, Mr. Neely's dead. I'm sorry for his family. But the reality of it is it really Mr. Penny's fault? Is it really the state's fault, the city's fault, that he didn't get the help he deserved? Yeah, color me skeptical on that one. Next, is there going to be a plea deal for the nightclub massacre? The suspect in a mass shooting at the Colorado Springs nightclub is expected to strike a plea deal to state murder charges and hate charges that would ensure at least a life sentence for the attack that killed 5 people and wounded 17. Now, word of the possible resolution of last year's Club Q massacre followed a series of jailhouse phone calls from the suspect to the Associated Press expressing remorse and the intention to face the consequences at the next scheduled court hearing this month. Anderson Lee Aldrich told the Associated Press that he has to take responsibility for what happened, and that was really his first public comment regarding the case. Now, the federal and state authorities and defense attorneys also have not made any statement, but under Colorado law, victims have to be notified of any such proposed plea dispositions, and several people who lost loved ones or were wounded in the attack have stated that the state prosecutors have given them advance word that Aldrich will plead guilty to charges that would ensure the maximum state sentence of life behind bars. Prosecutors also recently asked survivors to prepare for the June 26 hearing by writing victim impact statements and steeling themselves emotionally for the possible release of the Club Q surveillance video of the attack. Now, Mr. Aldrich faces more than 300 counts in state court, including murder and hate crime charges, and the U.S. Department of Justice is considering filing federal hate crime charges as well. And as you may recall, back on November 19th, when Mr. Aldrich walked into Club Q, the killing only stopped after a Navy petty officer grabbed the barrel of the suspect's rifle, burning his hands because it was so hot. An Army veteran joined in to subdue and beat Mr. Aldrich until police arrived, finding the shooter had emptied one high-capacity magazine and was armed with several more. Aldrich, who since his arrest has identified as non-binary and uses the pronouns they and them, allegedly visited Club Q at least 6 times in the year before the attack. And defense attorneys in previous hearings have not disputed that Mr. Aldrich had a role in the shootings, but have pushed back against allegations that it was motivated by hate, arguing the suspect was drugged up on cocaine and medication on the night of the attack. Let's face it, we've talked about this before, ladies and gentlemen. Being high on drugs is not a defense. If that were the case, there would be no crime because everybody could say we were on drugs and alcohol. Just throwing that out there for you as well. Just get tired of these stories. Tired of them. They're stupid. But this guy needs to go down as a coward. That's what he is. He's a coward and a killer and a coward. Next, the Moscow Mule mom is not helping herself. That's right, that Utah mom and the children's author accused of poisoning her husband apparently wrote an email to police attempting to explain why she was on an exotic vacation she took after the death of her husband. Now, Corey Richins allegedly poisoned her husband, Eric, with a fentanyl-laced Moscow Mule back in March of 2022. Now, before publishing a picture book to help children cope with losing a loved one. In an email to police while the death was being investigated, Richins addressed questions about why she took a lavish holiday while grieving his death. Well, she claimed that she didn't want to work because he feared. Miss Richins also claimed that her husband did not want her to work because he feared she would have an affair with a colleague like he claimed his ex-wife had done, and made reference to Eric's affair, claiming he had one at one point and cheated on her too. You ask about any exotic vacations I have taken since Eric's passing. I went on 2 trips last year, she wrote. One, my kids tried out at a soccer camp in Salt Lake City to qualify to play in Spain in June, and both my kids made it. So yes, I took them to Spain in October of 2022. In the months before her husband's death, Corey had attempted to make herself the sole beneficiary of the life insurance policy, and a police search warrant noted that Eric had expressed concerns his wife was trying to kill him, and that he had changed his will and power of attorney to give his sister full control before he was allegedly poisoned. Now, while investigations were ongoing, police found that Corey had taken a number of trips soon after her husband's death. Despite detailing 2 trips she took in 2022 in the email to police, she went on to also note a 3rd trip to Mexico 5 months after he died. I took my kids and my mom came with us back in August of 2022 to Mexico. I hope you understand. The months prior to this, since Eric's death, had been hard to deal with, she wrote. And although police probed the suspicious trips, the Utah mom claimed that her family routinely took overseas holidays every year. Also, Eric and I went to Mexico every year, sometimes twice. We traveled a lot. We have taken the boys to Mexico a few times, she noted. This is not new for us to go to Mexico or for us to go out of the country on vacation with our children. The email also saw Richins claim her husband did not want her working because his ex-wife had had an affair. She said that Eric wanted her to be a homemaker and a typical conservative wife, and her job as a real estate agent was threatening to him. Eric wanted us to live the typical conservative life where the man takes care of his family and the wife is the homemaker. This is not my personality and not the way I was raised. She said that she was raised to be very independent. Now, Eric had reportedly been carrying out an affair for some time before his death, but Richins says the couple had been trying to work through those marital issues. She added that she had been holding back from moving out of their home and had only threatened to do so to get him to end this alleged affair. Now, Richins detailed her mental health problems in the email to police, saying that she took medication after suffering postpartum depression after the birth of her child back in 2014. And she said she hoped to end the investigation into her husband's death as quickly as possible, including halting alleged harassment by private investigators and her husband's family. She said, I just want this over. I want our lives back and to move on and grieve and mourn my husband without looking over my shoulder constantly for you guys or the idiotic private investigators or the Richins family, she wrote. Whatever I can do to help close this out, you just let me know, and I'll do whatever you want to know. It's always the defendant's own words to come back and bite them, ladies and gentlemen. I hate to say it, she should have got herself an attorney. An attorney should have said, you know what, we're not going to answer any questions. If you have enough, charge her. Nothing particularly incriminating there, but, you know, the whole, I want this over with. It doesn't look good. All right, next, put this in the can't make this up file. An Illinois man is facing 2 felony firearm charges after accidentally shooting himself in his sleep while dreaming about a home invasion that he thought was taking place in his dream. Please meet Mark DeCara. Well, he mistakenly believed a burglar was breaking into his home after he dozed off on April 10th. Now, while dreaming he was fending off a criminal, he grabbed his .357 Magnum revolver and fired a shot into the darkness, only to wake up after he inadvertently shot himself in his own leg. Now, the investigation into the shooting found that when DeCara discharged the gun, the bullet went through his leg before lodging into his bedding. And after deputies found DeCara gushing blood from the wound, they applied a tourniquet to his leg and sent him to a hospital for treatment. Nice call. Good job, cops. No one else was harmed, and authorities quickly established that no home invasion had ever occurred that evening. And it was concluded that DeCara violated the Illinois state firearms law, as he was previously owned an identification card, but it had expired and revoked. Interesting. You actually have to have an identification card to have a firearm in Illinois? Are you kidding me? You don't need an ID to exercise a constitutional right. Are you kidding me? Anyway, officials have not confirmed the reason his license was revoked or when it occurred. Now, Mr. DeCara, to add a little insult to injury, is a semi-retired attorney practicing law in Illinois and Wisconsin. Next on the docket, did Richard Allen confess to being the Delphi murderer? Prosecutors allege in court at a hearing yesterday that Richard Allen confessed at least 5 or 6 times that he was the killer of the best friends, Abby Williams and Libby German, on that remote historic trail in Delphi back in February of 2017. He apparently has made multiple confessions to multiple people, according to the prosecutors, and Richard Allen's defense attorneys acknowledged that, quote, incriminating statements, end quote, made by Mr. Allen, but attributed the comments to his client's deteriorating mental state. Apparently, he has made incriminating statements implicating himself in the crime, Allen's defense attorney stated. And defense attorneys and prosecutors also argued Thursday that the statements previously made by the alleged Delphi murderer suspect, Richard Allen, include the reported confessions of the murder. I guess we're going to have to wait till early January of 2024 when the trial date was set to find out exactly what those statements may have been. Were they to a friend over a beer? Was it his wife, kid? Was it somebody in jail? I would like to know the context of this. But it's always the defendant's own words that come back and get them, ladies and gentlemen. They never believe their attorneys. Shut up. Shut up. That's what attorneys tell everybody. Shut up. Don't talk about the case to anybody other than your attorney. Anything you say can and will be used against you. Taken out of context, misconstrued, and bam, here you are, Mr. Allen. Or maybe you really did it. We don't know. So like I said, Mr. Allen's attorney said that these alleged statements were incriminating, and these statements obviously link him to the girl's death. The prosecutor said that they believe that Mr. Allen had made admissions. Prosecutor said that multiple confessions to multiple people were made. Now, during the hearing, there was a lot of talk about these reported confessions, but not much actually came out as to exactly what was said and to whom. Mr. Allen's attorney said, you can't believe those statements, can't be trusted because of their client's deteriorating mental state. They want him moved out of the Westville Correctional Facility to a county jail for his mental health and well-being. His defense team suggests that Allen has made these inconsistent statements since his arrest and attributed them to the stress of his captivity and his increasing difficulty to being able to communicate with his attorneys. The defense attorneys say that the mental and physical well-being has deteriorated since his arrest last fall. Obviously, the prosecutors disagree with that, and they say that Mr. Allen's treatment is nothing but humane. The judge will take it under advisement as to whether Mr. Allen should be moved to a detention facility. Now, the talk of all these statements was revealed for the first time on Thursday, so certainly there's more to come. And this is why the defense attorneys who said that their client was innocent, and I guess I get it, you make the statement, there's a presumption of innocence, they're going to vindicate their client. Sometimes you got to wait to actually review the discovery before you start making statements that you can't make. So anyway, jury trial will begin in early January, and the jury will be selected in a different county and then bused back to Colton County for the jury trial. Next on the docket, our dumb criminal of the day just happens to be a police officer. A Florida police officer was arrested after speeding in his police cruiser while on the way to work. And then he began arguing with a sheriff deputy and then sped off. Alexander Shaouni, Shaouni, go with how you want to pronounce it. Well, he was allegedly driving about 80 miles an hour in a 45-mile-an-hour zone without his police lights on or sirens, and he was pulled over last Friday. And the Seminole County Sheriff's deputy stopped the Orlando police officer after he saw him race past a local road and had to drive at least 100 miles an hour to catch up with the police officer. Once Shannoni pulled over, he argued with the deputy, asking him why he was being stopped, as he was going to work, and refused to hand over his driver's license. He then took off in the police car and was later charged with resisting an officer, reckless driving, and fleeing and eluding a law enforcement officer with lights and sirens active. The suspected officer was then suspended from the Orlando Police Department while the investigation takes place. If he had just been nice about it, I'm sure the deputy would have given him a little professional courtesy and said, "Hey, man, I'm busy. Got to do that police stuff." But no, he didn't. That's just arrogance, ladies and gentlemen. All right. It was a long show for you today, a big show for you today. I hope you enjoyed it. Have a wonderful weekend, and we will see you next time on Crime Talk.